On March 14th, two retired bureaucrats, Gyanesh Kumar and Sukhbir Sandhu, were appointed as election commissioners just 2 days ahead of the announcement of the dates of the 2024 Lok Sabha elections. They are now part of the three-member Election Commission of India panel, headed by Rajiv Kumar, the Chief Election Commissioner. The two officials are the first to be appointed under the new law governing appointments to the constitutional body, the Chief Election Commissioner and other election commissioners, Appointment, Conditions of Service and Term of Office Act 2023. Under the new law, the two commissioners were selected by a three-member selection committee comprising Prime Minister Narendra Modi, Union Home Minister Amit Shah, and the leader of the Indian National Congress in the Lok Sabha, Adhir Ranjan Chowdhury, as leader of the largest party in the opposition. The election commissioners were chosen out of a shortlisted panel of 6 names. The shortlisting was done by a search committee which, according to the Act, is headed by the Union Minister for Law and Justice and includes 2 officials of the rank of Secretary to the government. For nearly 40 years from the adoption of the Constitution, the EC only had a Chief Election Commissioner. The Constitution does not lay down a specific legislative process for the appointment of the Chief Election Commissioner and election commissioners. Article 324 of the Constitution says, the Election Commission shall consist of the Chief Election Commissioner and such number of other election commissioners, if any, as the President may fix from time to time. This provision was subject to any law made in that behalf by Parliament. In the absence of any particular process being laid down by parliamentary law, the President has been appointing the Chief Election Commissioner and other election commissioners. The only known process is that the Law Ministry puts up a panel of names to the Prime Minister, who recommends the appointment of one of them as Election Commissioner to the President. It had become a convention to appoint officials as election commissioners first, and then, on the completion of the tenure of the Chief Election Commissioner, the Senior Election Commissioner was elevated as the Chief Election Commissioner. Earlier this month, the 2 vacancies sprung up following the retirement of Anup Chandra Pandey and the resignation of Arun Goel. When Goel took over the post in 2022, it came in the midst of a constitution bench hearing for a truly independent process of selecting members of the panel that conducts and supervises India's elections. The foremost criticism from those who have challenged the new act is that it has removed the Chief Justice of India from the selection panel and has made a union minister a member instead. This gives the executive a 2-1 majority in the 3-member committee. To understand the differences between the 2 appointment procedures and the Supreme Court angle, we spoke to K. Venkataramanan, Senior Associate Editor of The Hindu.
This is a very subjective, matter. First, we should remember that there have been several chief election commissioners who have been appointed by the executive, but who have demonstrated some degree of independence and autonomy over the years. There have also been allegations of some chief election commissioners being partisan. In the light of that, what the Supreme Court did last year was that when there was a petition which wanted an independent mechanism for the appointment process, they laid down a law that the principle of independence must be preserved in the manner of appointment too. They noticed that Parliament had failed to enact a law in the 75 years of the working of the Constitution. So they decided that, to fill this vacuum, the court itself can step in and lay down a mechanism. And they made it clear that this arrangement will be only until Parliament enacts its own law, because Article 324 of the Constitution, which basically deals with the powers of the Election Commission, it says the appointment of the Chief Election Commissioner and the election commissioners will be done by the President until a law in this behalf is made by Parliament. So since that law was never made, the President has been appointing the authorities based on the advice of the Cabinet or the Prime Minister. So what they did was they decided to borrow on some of the mechanisms that have been evolved in recent years for the appointment of functionaries like the director of the CBI and the chief vigilance commissioner, by which they formed a small panel, a collegium consisting of the Prime Minister, the leader of the opposition, and the Chief Justice of India. These are the same people who, elect the CBI director also. So, there was a question whether when Parliament ultimately enacts a law, they will retain the role of the CJI. Ultimately, Parliament didn't do that. They instead evolved a mechanism by which the Prime Minister and the leader of the opposition, or if there is no recognized leader of the opposition, the leader of the largest party in opposition will be the two members, and the third member, they decided that it will be another member of the Union Ministry. So basically, the cabinet is represented by two representatives and the opposition is represented by one. So this 2-to-1 majority for the executive is being seen by some as, taking away the independence of the executive. See, once again, if you see this issue in the light of what the court actually wanted, it was a constitution bench judgment. The court wanted a mechanism by which an election body that is to conduct free and fair elections should have an appointment process that should also be free and fair. So they decided that giving the executive a say will not, help this cause of an independent mechanism. That's why they had a mechanism in which the Chief Justice of India was given a role. Whether the third member should be the Chief Justice of India or any other independent representative was right now only academic. But the primary criticism is, if the government is allowed to appoint the election commission of the day, and who later on becomes the chief election commissioner as soon as the current CEC retires, then this process may not be the best one to ensure or procure the independence of the election commission itself. This is the substance of the criticism against the new law. When the executive has appointed so many functionaries in the past, until the collegium system of appointment was introduced for the higher judiciary, even the Supreme Court judges and High Court judges were appointed by the government. They even had power of transfer. And despite this, we had a fairly vibrant judiciary. So it is possible to argue that despite the executive having a say in the appointment, it does not automatically lead to a conclusion that the election commission will not be independent. But people usually draw on recent experience, and recent experience has been that the election commission has received a lot of criticism about being, partial towards the government or the ruling party at the center. In the light of this, an independent mechanism will be better for the country in the long run. That's what I wanted to say.